Okay, this is going to be 15 minutes at 220 words a minute. So this will be a nice little endurance drill for you. 15 minutes. Ready? Ready? I will now instruct you on the law to be applied in this case. You must take the law as I give it to you, and if any attorney or any witness or exhibits has stated a legal principle different from actions, it is my instructions that you must follow. The instructions as a whole constitute the law of this case and must be applied as a whole. You should not single out any one instruction alone as stating the law, regardless of any opinion you may have as to what the law is or ought to be. It would be a violation of your sworn duty to base a verdict upon any view of the law other than the instructions of the court. It would also be a violation of your sworn duty if you were to base any findings of fact on anything other than the evidence presented to you in this case. Role of the jury. As members of the jury, you are the sole and exclusive judges of the facts. You pass on the evidence, you determine the credibility of the witnesses, you resolve such conflicts as there may be in the testimony. You draw whatever reasonable inferences you decide to draw from the facts as you have determined them, and you determine what the weight is of the evidence. In determining these issues, no one may invade your province or function as jurors. In order for you to determine the facts, you must rely upon your own recollection of the evidence. The government as a party. You are to perform the duty of finding the facts without bias or prejudice as to any party, and with an attitude of complete fairness and impartiality. The fact that the prosecution is brought in the name of the United States of America entitles the government to no greater consideration than that accorded to any other party to the litigation. By the same token, it is entitled to no less consideration. All parties, whether the government or individuals, stand equal before the law and are to be dealt with as equals in a court of justice. However, it is the government which bears the burden of proving the defendant's guilt beyond a reasonable doubt. Similarly, under your oath as jurors, you are not allowed to be swayed by sympathy. You are to be guided solely by the evidence in this case, as the crucial, central question you must ask yourselves as you sift through the evidence is, has the government proved the guilt of the defendant beyond a reasonable doubt? It is for you alone to decide whether the government has met its burden of proof on the crimes charged based only on the evidence introduced and subject to the law as I charge you in these instructions. If you let fear or prejudice or bias or sympathy interfere with your thinking, there is a risk that you will not arrive at a true and just verdict. Burden of proof, reasonable doubt, and presumption of innocence, although the defendant has been indicted. You must remember that an indictment is only an accusation. It is not evidence. Defendant has pleaded not guilty to the indictment. The law presumes the defendant to be innocent of the charge against him. The burden is on the government to prove the guilt of the defendant beyond a reasonable doubt on each element of the crimes charged. This burden never shifts to the defendant for the simple reason that the law never imposes upon a defendant in a criminal case the burden or duty of calling any witness or producing any evidence. I therefore instruct you that you must presume that defendant is innocent throughout your deliberations until such time, if any, that you as a jury are satisfied that the government has proved his guilt beyond a reasonable doubt. You may not infer that defendant was guilty of participating in a criminal conduct merely from the fact that he associated with people who were guilty of wrongdoing, and defendant is not on trial for any act or any conduct not specifically charged in the indictment. In short, defendant begins the trial with a clean slate, and this presumption of innocence alone is sufficient to acquit him, unless after careful and impartial consideration of all the evidence in the case, you as jurors are unanimously convinced beyond a reasonable doubt of his guilt. Reasonable doubt is a doubt based upon reason and common sense. It is a doubt that a reasonable person has after carefully weighing all of the evidence. A reasonable doubt may arise from the evidence itself or lack of evidence. It is a doubt which would cause a reasonable person to hesitate to act in a matter of importance in his or her own personal life. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. It does not require that the government prove guilt beyond all possible doubt. Proof beyond a reasonable doubt is sufficient to convict. A reasonable doubt is not a caprice or a whim. It is not a speculation or suspicion. If after a fair and impartial consideration of all the evidence you have a reasonable doubt on any element of any one of the crimes charged, it is your duty to acquit the defendant of that charge. On the other hand, if after a fair and impartial consideration of all the evidence you find the defendant's guilt beyond a reasonable doubt, you should vote to convict the defendant on that particular count. Prove and find. Each element must be established beyond a reasonable doubt. You should understand that whenever I say that government has to prove a fact to you, I mean that it has to prove that fact to you beyond a reasonable doubt, as I just explained that term to you. You are to understand my use of the word prove to mean beyond a reasonable doubt, even if I do not always repeat those words exactly. Similarly, when I say to you that you must find a fact in order to return a guilty verdict, you must find that fact to have been proved by the government beyond a reasonable doubt. Even if I simply use the word find, defendant's election not to testify. The defendant did not testify in this case. Under the U.S. Constitution, he has no obligation to testify or to present any other evidence, because it is the government's burden to prove the defendant guilty beyond a reasonable doubt. The burden therefore remains with the government throughout the entire trial and never shifts to the defendant. In our system, no defendant is ever required to say or do anything, or to prove that he is innocent. You may not attach any significance to the fact that the defendant chose not to testify. No adverse inference against him may be drawn by you because you did not take the witness stand. You may not consider that against the defendant in any way in your deliberations in the jury room. Role of the attorneys. Our courts operate under an adversary system in which we hope that the truth will emerge through competing presentations of adverse parties. It is the role of the attorneys to press as hard as they can for their respective positions. In fulfilling that role, they have not only the right but the obligation to make objections to the introduction of evidence that they feel is improper. The application of rules of evidence is not always clear, and lawyers often disagree. It has been my job as the judge to resolve these disputes. It is important for you to realize, however, that my rulings on evidentiary matters have nothing to do with the ultimate merits of the case, and are not to be considered as points scored for one side or the other. During the course of this trial, there have been occasions for the attorneys to confer with me out of your hearing. In the interest of justice and in order to expedite trial, it is perfectly proper that conferences be held here at the bench between counsel and the court, because this serves to avoid the inconvenience of having the jury file out and back in again. In such situations, you should not feel slighted. You are not to muse or venture on what was being discussed, and likewise, you should have no resentment toward the attorney who requested the sidebar conference. Similarly, one cannot help becoming involved with the personalities and styles of the attorneys, but it is important for you as jurors to recognize that this is not a contest among attorneys. You are to decide the case solely on the basis of the evidence. Remember, statements and characterizations of the evidence by the attorneys are not evidence. Insofar as you find their closing arguments to be helpful, take advantage of them. But it is your memory and your evaluation of the evidence in the case that counts. What is and is not evidence? The evidence in the case is the sworn testimony of the witnesses, regardless of who may have called them, the exhibits received in evidence, regardless of who may have produced them, and all facts which may have been stipulated to by the parties. What the lawyers have said in their closing arguments, in their objections, or in their questions is not evidence. If the witnesses' answers, it is the witnesses' answers that are evidence. At times, a lawyer on cross-examination may have incorporated into a question a statement which assumed certain facts to be true and then asked the witness if that statement was true. If the witness agrees to it, you may find those facts to be true, but you may not consider it to be true simply because it was in the lawyer's question. As a simple example, if the lawyer asks the witness if a certain car was red and the witness says yes, that is evidence that the car was red. If the witness says no, that is evidence that the car was not red. If the witness says he or she does not know, then there is no evidence in the record as to what color the car was. You may not consider any answer that I directed you to disregard or that I directed to be struck from the record. Do not consider such answers. You should also disregard evidence as to which an objection was sustained. A stipulation is an agreement among parties that a certain fact is true. In this case, parties have entered into various written stipulations which will be marked as a court exhibit and which you will have in the jury room during your deliberations. You may regard such agreed fact as true. Arguments or statements by the lawyers are not evidence because the lawyers are not witnesses. What they said to you in their submissions was intended to help you to understand the evidence from their viewpoint in reaching your verdict. However, if your recollection of the facts differs from the lawyer's statements, it is your recollection that controls. Further, anything you may have seen or heard about this case outside the courtroom is not evidence and must be entirely disregarded. In addition, materials used only to refresh a witness's recollection are not evidence. But if recollection is refreshed from those materials, such testimony is evidence. Exhibits which have been marked for identification but not received into evidence may not be considered by you as evidence. Only those exhibits received as full exhibits may be considered. Moreover, what I have said during the trial or what I may convey in these instructions is not evidence, and my rulings on the admissibility of evidence do not, unless I expressly give you a limiting instruction indicate the weight or effect of such evidence. It is for you alone to decide the weight, if any, to be given to the testimony you have heard and to the exhibits you have seen. Transcripts of tape recordings. There were transcripts of telephone tape recordings which were shown to you on the screen as an aid to guide or assist you in listening to the tapes. These transcripts, however, are not evidence. You alone will make your own interpretation of what you heard on the tapes. If you think you heard something different than what appears in the transcripts, then what you heard is controlling. The record of the prison telephone calls are on the tape and can be played back for you if you need that. Direct and circumstantial evidence. There are two types of evidence which you may properly use in deciding whether the government has or has not proven that the defendant is guilty beyond a reasonable doubt. One type of evidence is called direct evidence. Direct evidence is a witness's testimony as to what he or she saw or heard or observed. In other words, when a witness testifies about what is known to him or her by his or her own knowledge, by virtue of his or her own senses, what he or she feels, touches, or hears, that is called direct evidence. Circumstantial evidence is evidence which tends to prove a disputed fact by proof of other facts. You infer on the basis of reason and experience and common sense from an established fact whether or not some other fact has been proven. Circumstantial evidence is of no less value than direct evidence. The law makes no distinction between direct and circumstantial evidence, as I have explained before. You must be satisfied with the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Speculation, guesswork, or intuition cannot be substituted for proof. You must be satisfied beyond a reasonable doubt from all of the evidence, whether it be direct or circumstantial, that the government has proven the defendant committed the crime set forth in the indictment. That is, the government's proof establishes every element of the crimes, as I shall later describe them to you. Inference, defined during the trial, as well as these instructions. You have heard the term inference, and you have been asked to infer on the basis of your reason, experience, and common sense from one or more established facts the existence of some other fact. An inference is not a speculation or a guess. It is a reasoned, logical decision to conclude that a disputed fact exists on the basis of another fact which you know exists. There are times when different inferences may be drawn from the same facts. The government may ask you to draw one set of inferences, while the defense may ask you to draw another. It is for you and you alone to decide what inferences you will draw. The process of drawing inferences from facts in evidence is not a matter of guesswork, speculation, or intuition. An inference is a deduction or conclusion which you, the jury, are permitted to draw but are not required to draw from the facts which have been established by either direct or circumstantial evidence. In drawing inferences, you should exercise your common sense and may draw such reasonable inferences from the facts as you find to be justified in the light of your experience and common sense. Witness credibility. Generally, you have an opportunity to observe all of the witnesses. It is part of your job to decide how believable each witness was in his or her testimony. As I have said, you are the sole judges of the credibility of each witness and the importance of his or her testimony. It must be clear to you by now that you are being called upon to resolve various factual issues in the face of very different pictures painted by the government and the defense. In deciding whether the government has proved its case beyond a reasonable doubt, you will be making judgments about the testimony of the witnesses you have listened to and observed. In making those judgments, you should carefully scrutinize all of the testimony of each witness, the circumstances under which each witness testified, and any other matter in evidence which may help you to decide the truth and the importance of each witness's testimony. Your decision whether or not to believe a witness may depend on how that witness impressed you. Was the witness candid, frank, and forthright? Did the witness seem as if he or she was hiding something, being evasive or suspect in some way? How did the way the witness testified on direct examination compare with how the witness testified on cross-examination? Was the witness consistent in her testimony, or was the witness's testimony contradictory? Did the witness appear to know what he or she was talking about? Did the witness strike you as someone who was trying to report his or her knowledge accurately? How much you choose to believe a witness may be influenced by the witness's bias. Does the witness have a relationship with the government or the defendant that may affect how he or she testified? Does the witness have some incentive, loyalty, or motive that might cause him or her to shade the truth or to be fully truthful? Does the witness have some bias, prejudice, or hostility that may have called the witness, consciously or not, to give you something other than a completely accurate account of the facts he or she testified to? Or does the witness have an incentive to be accurate? Even if a witness was impartial, you should consider whether the witness had an opportunity to observe the facts he or she testified about. You should also consider the witness's ability to express himself or herself. Ask yourself whether that witness's recollection of the facts stands up in the light of all the other evidence in the case. You must decide the accuracy, credibility, trustworthiness, and reliability of the evidence. The weight of the evidence as to the particular fact is not determined by the number of witnesses or exhibits, nor by which party produced the most witnesses or exhibits. It is the quality of the evidence that supports the finding as to a particular fact that should control whether that evidence comes from a single source or many sources. In sum, what you must try to do in deciding credibility is to size a person up in light of his or her demeanor, the important information and explanations given, and all of the other evidence in the case, just as you would in any important matter where you are trying to decide if a person is truthful, straightforward, and accurate in his or her testimony. In deciding the question of credibility, remember that you should use your common sense, your good judgment, and your experience. Witnesses' credibility. Impeachment by prior inconsistent statement. You have heard that certain witnesses made statements on earlier occasions which counsel argue are inconsistent with those witnesses' trial testimony, with some exceptions, which I address in the next section entitled Inconsistent Sworn Testimony. Evidence of a prior inconsistent statement is not to be considered by you as affirmative evidence, because this evidence was placed before you for the more limited purpose of helping you decide whether to believe the trial testimony of a witness who contradicted himself. If you find that a witness made an earlier statement that is inconsistent with his or her trial testimony, you may consider that fact in deciding how much of his or her trial testimony, if any, to believe. In making this determination, you may consider whether the witness purposely made a false statement or whether it was an innocent mistake, whether the inconsistency concerns an important fact or whether it had to do with a small detail, whether the witness had an explanation for the inconsistency, whether that explanation appealed to your common sense, and whether the alleged inconsistent statement was made at all. It is exclusively your duty, based upon all of the evidence and your own good judgment, to determine whether the prior statement was inconsistent, and if so, how much weight, if any, to be given to the inconsistent statement in determining whether or not to believe all or part of the witness's testimony. Prior sworn testimony. During the course of this trial, you have heard testimony from witnesses who have previously appeared and testified under oath, either before the grand jury or at some other proceeding.